Yes, now we're back. Welcome back to the last stretch of the conference. I think everyone's had the sugar rush. Is our energy back again? Back in a sense that, are we on detox, social media detox? Okay, I think for the last part, just before we commence with our panel, I'd like to ask you guys to just continue tweeting, #OwnYourForce. And in this panel, titled Find Your Way Through Frameworks, it's a panel of legal and policy experts. I was sort of like rushing the time because I am a political scientist, but I did my master's in public policy. So this is a subject of interest for me, very selfish. But this is a panel of legal and policy experts that will engage around intellectual and creative property ownership, local and cross-border legal frameworks, and the use of copyright, patents, trademarks, and etc. in policy, and the context of the CCIS, followed by, we'll just have this panel, and then we'll have the conversation drive itself. I trust you gentlemen are experts in this field. Look at them already being modest, and we haven't even started talking. Okay, so I'll introduce Leroy Bell from Delgro, and we have Ashraf Patel from IGD, and Thomas Reisenberger from Legalese. Gentlemen, please give them a round of applause. I'll ask for you guys to just each do your presentation. I'm not sure if you have prepared presentations, or you'll just speak. Look at that. Okay, take it away. No, you can. It's pretty relaxed.
Okay. So, I'm Elroy, by the way. So good afternoon, everyone. It's always such a worry to be on the last panel of the day. I mean, we're likely to be booed off the stage because people want to run off to traffic, or because you're about to fall asleep from the carbicide that you just had off the little bits of cake. And I honestly don't know what's worse. But we're here, and we're happy to be here. So thank you to the Fakugezi Digital Innovation Festival for putting this together and the invitation to speak. I don't feel particularly qualified to be here, but I'm here now, and I have the mic, so you can't take it away. So I wanted to thank the organizers and the sponsors for creating the space, particularly the Goethe Institute, Creative Economies Platform, and the British Council, and everyone else that has sponsored. I'll be speaking from my background working in the industry, managing IP for a couple of arts organizations I've worked for, and now as a rights management agent and the department head for artistic visual arts and theatrical licensing for Delro. So it's afforded me a wider breadth of particularly nuanced issues of licensing and the commodification of intellectual property than most people have within the creative industries. This panel has also given me the kick in the backside to kind of formulate a lot of my research ideas that I have for my MA into a more coherent format. So thank you for that. As we've all become aware, Johannesburg is one of those perfect sort of microcosms of which to observe the shift in resource-based industries to knowledge-based economy. Government has noticed the importance of Fourth Industrial Revolution in light of the diversification of the country's economic landscape. Indicative of this is the relative contribution of mining in South Africa's GDP has declined over the last 20 years. We're also aware of the fact that, that access to fast and affordable internet has become something of a basic human right. So, and imminently the cost of data will fall as they open up more bandwidth and frequency in the country. But the question remains, what does this mean for the cultural and creative industries, specifically around intellectual property? It's ironic that this topic is entitled Finding Your Way Through the Frameworks, when a lot of the frameworks don't exist yet. So in reality, there's very few that exist for what we currently already have, and nothing in relation to what's coming. So we're a victim of slow bureaucratic process, legislators that do not have the technical understanding necessary when drafting laws and processes, and lobbying rooted in electioneering and quick gains, but what's new? So as we sit here, in terms of the legislative framework that I'm only going to touch on, the Copyright Amendment Bill is sitting with President Ramaphosa's desk, on President Ramaphosa's desk, along with a stack of other bills waiting for his signature. It's been a particularly contentious bill, with lobbying for both intellectual property creators and IP users making their cases. The act is from 1978. No one is disputing the fact that it needs to be updated. Absolutely no one is disputing that it needs updating. I think all we're looking for is some well-drafted legislation that doesn't wipe out revenue streams for creators and is balancing that fine line of what a reasonable royalty is and clearly understood areas for exception. I won't make this discussion about the bill because honestly, I am tired. We have been discussing this bill for about 3 years. More than that maybe. And I think all of us sitting on this board, on this panel, are just mukh from this copyright amendment bill. Because at the end of the day, the President Ramaphosa can only send it back to Parliament, to the National Assembly, based on constitutional reasons. And should that happen, the whole process of consultations that no one listens to will start all over again. So that's where we're at. On the other side, the parliamentary subcommittee on the process for the amendment for Section 25 of the Constitution was supposed to meet yesterday, but unfortunately there was no quorum among the MPs, so the first meeting's been postponed. Why am I bringing up Amendment 25, you might ask? It's because it's the part of the Constitution that deals specifically with property, all property, of which intellectual property is obviously one. And at this stage, while we know we're talking about physical land, which we know needs to be redistributed, we haven't seen draft provisions of that amendment yet. So perhaps it's the alarmist in me. If it's not drafted correctly or accurately, will IP form part of it? I mean, as applied in the realm of human creation, property generally refers to a right to exclude others from deriving all or part of the value of a certain defined object. So that sounds obviously like IP. Technology and copyright law possess a symbiotic relationship that has remained practically untouched for more than a century now. However, we live in an exciting era of innovation and transformation, particularly in the cultural and creative industries. We've already had pilots of theater seats that will be able to track our enjoyment of a theater piece. It might have been a marketing novelty at the stage, but I say give it 6 months. Pretty soon we'll be able to offer tailored productions to enjoy in that performance space, linked to your cookies and your cell phone search history. On personalized loyalty programs for that respective arts organization. We've spoken about, and we see it already, galleries incorporating AR and virtual reality tours where the artist themselves is guiding you through the exhibition, talking about their process and inspiration. So we're living in a time, separate from that as well, we're also living in a time desperate to create community in solitude. I mean, we heard it in the social media talk before as well. We're curating communities on hashtags, and hashtag men are trash. It's something that I fully understand, and to be honest, we are, and also we're the only men on this panel. So we're relying on technology to offer us security as women who do not feel safe walking past our neighbors now. We shout into the ether to find solace and commiserate our shared mourning of someone we feel so close to because of the glimpse we've been given into their social online footprint and the beauty of technology to connect us. But what specifically does this mean for IP? I really honestly don't know. Honestly, artificial intelligence systems have been developed that emulate to a certain extent the human creative process, such as the conception of artistic works, literary works. This has a direct impact on the legal framework that surrounds these works, questioning whether the current legal framework of copyright is still capable of effectively protecting and incentivizing human creation. One particular paper I read spoke to how we will likely need to attribute intellectual property to an AI system, as it will have learnt by itself how to create and what to create. That AI system could be seen as a legal person in the same way the law recognizes a corporation as such. So the European Union is placing more responsibility on digital platforms to monitor IP on their sites, given the amount of money generated from advertising revenue piggybacking on individual intellectual content. Our own new copyright amendment bill hasn't been able to grapple with either of these concepts. So yeah, something to think about. Existing arts and IP organizations are facing disruptions as with any other industry. The ability to self-publish literature and music and market everything from your cell phone and control the entire value chain is leaving the music industry and the publishing houses very concerned. We must adapt or die, they keep telling us. So even in the rights management industry, we've built code that can be embedded as metadata into artistic and literary digital files to track how and when these are being used across the globe in real time, thereby tracking copyright infringements instantly and giving us a breadth of analytical data that will inevitably further shape how we create in terms of how we consume. In the same way that blockchain currency has disrupted the financial industry with Bitcoin and Facebook's imminent launching of their own cryptocurrency, I think it's called Libra, which will no doubt explode the accessibility of these products into the baby boomer generation as well. Blockchain IP platforms exist which will force collective management organizations such as your SAMRO, such as your DALRO, such as your SAMPRA, your CAPASO, just in South Africa. We heard earlier about collective management organizations in Kenya. It'll force them to seriously reconsider their value proposition in the cultural and creative industries. I mean, blockchain IP allows a creator to be inextricably linked from the work that is created and potentially shift. And so in many ways, it'll moot the legal need for an author to prove originality because the system will already have it inextricably linked to that person. And then it'll also potentially shift the way and process in which trademarks and patents are awarded. So as with anything in our current climate, creators are wanting more control over their own property. Crypto keys or licenses will be granted with a payment or royalty through an e-market site that will instantaneously give a user permission and access to content based on permissions set by the IP owner directly. Where does the CMO fit into that? So exciting times lay ahead, but with innovation comes a host of questions we don't even know need to be asked yet, let alone the answers. So hopefully this is a really great discussion. So thank you very much.
So Ashraf, I think while we move to you, you're more in the policy space around the continent, regional side of things. And while Leroy? Elroy spoke about the fact that the framework is sitting on the president's desk and picking up dust, hopefully not, and that this digital world is constantly changing, right? What we did yesterday is completely different now. I mean, I know my grandmother thinks Google has the answers to everything, and I constantly have to warn her not to go on Google all the time. But from a continental perspective around adopting these policies, and these are digital policies. I know earlier on during lunch we spoke about the GDPR, and my feel was, as a creative entrepreneur, how is the GDPR relevant for me in South Africa? And how is this affecting our framework that hasn't been passed?
Okay, good question. Thanks, Elroy. Thanks, Dudu and the Goethe Institute and others. I think this is a very dynamic discussion. If I were to throw back 15, 18 years ago, the very first IP social contest in South Africa was the access to essential medicines. If people recall that bill, WIPO wanted to enforce the rights of pharmaceutical companies to sort of provide it and protect their patents in the field of drugs for HIV and TB patients. And South Africa was the site of the very first struggles around the pushback of the WIPO, i.e. WTO discourse at the time. And in fact, very successfully, that generated one of the most successful social justice movements, i.e. the Treatment Action Campaign. And that globally is still held as a global standard in sort of modifying an IP system to sort of fit within some developmental a path of, let's say, a developing world. And we do have that experience and a very strong community, social justice, advocacy sector in South Africa. And I think that's an excellent resource. I think, looking at the copyright, I'm not specifically in the copyright sector. I would look at it broadly as the IPR and technology for development sector. And we work a lot with the Sub-Saharan Africa, AU, developing South, Brazil, India, Mexico, etc. And in many ways, we mirror the pathways of the developing world. South Africa is a developing nation that has all the contradictions of the first, third, and fourth worlds that live cheek and jowl together. And that contestation is very, very intense. What makes this unique, in my view, is that, as Elroy rightly pointed out, we're going through structural transformation as a country, particularly primary industries. Manufacturing now is also in decline with the so-called fourth industrial revolution. So we're beginning to see massive structural change in traditional industries. And rightfully so, culture or creative industries are growing in leaps and bounds with everyone having access to the technology. Hence, the debate is going to get more intensive. The stakes are very high. And I'm not surprised, Elroy and team, that we've had this contested debate at the copyright bill. And I think just over tea, I said, I'm somewhere in between. I don't follow the full libertarian view, nor do I follow the socialist view. I would take a more social democratic balanced view of the matter. I believe all stakeholders have an important sector because at the end of the day, it's livelihoods, and particularly artists or writers who are the creatives. Let's call them the Leonardo da Vinci's of their work. They feel, rightly so, their livelihood. And I think if any of the bill or its provisions somehow affect that, then naturally they're feeling very, let's say, emotional about it. But I also want us to take a broader perspective. Copyright bill is just one of four very relevant legislations. We have the IPR bill, very little debate around that. And sadly, it's left to industry to run with it, and we haven't had societal participation. There's something even more important for Africa is what is called the indigenous knowledge systems.
I can't believe we still use the word indigenous.
Well,
in 2019.
Yes. No, the department called it IKS, Indigenous Knowledge Systems. But that is basically to preserve African traditions, culture, and practices. And how do you preserve that in a digital economy? Now, a very good case some years ago was the San community. Yeah, the Hoodia plant is the San community's resource. And Unilever, which is a UK multinational, then had the rights to it. And there was a very interesting debate. But in the end of the day, I think the case fell through, or I haven't followed the case, but what it brought out was how do we preserve indigenous culture within our communities? What is the role of law? How do we regulate large corporations, especially multinationals? Because they need the content or they need the indigenous knowledge to go global. Now that is where the real contest is going to be. And I think we need creative solutions. And then the final one, of course, is less relevant, is the Patents Act. Which is, so these four somehow are sort of playing into that space. It's fascinating as a public policy analyst. For us, we can write case studies about it, and it can better inform the legislation. I think we're living in fascinating times.
I'm glad you mentioned patents because it tees in with what Thomas does, right? I liked, so I was going through your website and it says, we are not lawyers. When you get arrested, do not call us.
Please don't call us.
But we are here for your business needs. So if you have questions or you need protection around your businesses, your small startups, we're your guys. And this is very interesting because, and especially from a social enterprise / creative entrepreneurship, right? Startup model. I like right? So I was going through your website. You can't afford a lawyer. We are not lawyers. When you get arrested, great do not call us. That will bring about big impact in the lives of the community and essentially the country at large. And you have a meeting with this big corporate, and the first question you ask is, can we sign an NDA? Is this enough to protect my IP? Does this protect my patent, Thomas?
Very, very good point. So morning, everyone. Like I said, attorneys, but we're legal advisors. And what's great is, in actual fact, our idea was created by my boss, who found that he was in the creative sector himself. He was a DJ, and he looked around, and there was no one able to offer them legal services. So in actual fact, we started as a legal advisory that assists people getting around the law, but using realistic fees and things like that, and bring it really to the people. But on the NDA point, because this is one of the biggest things, and I think it might upset kind of a few people, but there's a lot of speak about law. I hate to say it, but sometimes the law is not going to matter, okay? We advise we've got 2,000-3,000 clients in our practice. Guys, your NDA, your terms and conditions, all of that sorts of things, they can be perfect, but they will work as perfect deterrents. They will not prevent theft, okay? Theft is inevitable. So one of the things I'll kind of be mentioning later is, in light of that, what do you do? Okay, so that NDA, exactly that situation there. If you fall asleep now, the most important thing I can just tell you now, as my little takeaway, is remember to always sell yourself as the value proposition, not the product. The product I can replicate. The product will be done by a computer in 6 months to 2 years. Someone else will come up with it. If you are not attached to the product, then it's useless. And that's what we always say to clients. So in a situation of an NDA, definitely have it as a deterrent. Be realistic in the sense that if you walk into a meeting with a 45-page NDA, I will tell you to go away, okay? Because I don't trust you, and you're showing that too. So NDA is good as a deterrent, and it's there to make sure that we understand what the kind of terms of reference, how we deal with each other as a relationship, because that's all that law is. But people must be very realistic about the fact that theft will happen, and it's about making yourself the most valuable part of the proposition you're trying to sell. Because without you, it's useless. Without you, they can steal it. Go ahead. It's useless. Okay, so that's one thing I just want to make very, very clear, especially in the cultural and creative industries, is that you guys bring the value. Okay? So, interestingly, in the context of what we have now, and typical law, we focus on the nitty-gritty, is that our old laws, exactly as mentioned, are defunct. Okay? Written in the 70s, internet wasn't around. And strangely, what also happens now is that there's an incongruence between the laws. So patents, under the Patents Act, specifically exclude software programs. Right? It says so specifically, it's excluded. Where do they put computer programs? In copyright. Now there's a problem with that. Because copyright is about the manifestation of a thing, an object, right? It's the code. It's the code written down. The problem is that people can steal a lot faster and manipulate a lot faster than they could in the past using technology. So what we have an issue now with is the fact that something like coding, which is probably some of your most valuable IP as the basis for modern technology, apps, services, all I gotta do is find your code, change 1 or 2 lines, and because coding can be entirely affected by the effect of 1 line, I insert the 1 line, what's happened? You've lost copyright. The nature of what you have created is entirely different from what I have now created. So it's now mine. So now we've got a problem. The laws don't help us. So now the question is, okay, well, what does help us? And this now leads me kind of into the realm, and I hope this is a practical thing for you guys, is I want you to think about IP under the field of contract and practical protection. One of the things I mentioned about practical protection was exactly that. When you go into the meeting, make yourself the most valuable asset, not the product, okay? Other practical tools. There's a lot of cool tech out there, guys. Have you ever tried to do a right-click copy on a Getty Images? You can't. Why? Because there's tech behind it saying you can't copy this image. You can get the same thing yourself. You can put a watermark across your images. You can put even a simple little copyright thing there. These are all deterrents. But ultimately, we practically have to understand that theft does exist. We just need to be very ready for it. By the way, that contract thing, so I spoke a bit about the practice. The contract side, this is for all people that do things online especially. The great thing about online is that people have to come to a single point to come get your IP. They have to come to your platform. They have to come through your landing page, they have to come through your app. And the great thing is, the moment they push accept, what can you make them do? Accept the T's and C's. Their use of your product is subject to a contract, T's and C's. And what do we do for our clients in those T's and C's? And please do it for yourself. Have a nice fat intellectual property policy. And what does the intellectual property policy do? It says everything you see on the website, everything running the website, all the code, the layout, the UX, the images, it's mine. Don't use it. If you use it, what are you doing? You're breaching contract. And I sue you for damages. I'm not relying on any of the old laws anymore. So this is a practical solution of what it means in the face of our current situation where the law is unclear, the law is old, right? Bring it into a realm that works. And what we do is we push it under contract or we push it under practical solutions. So think about those two things in practice. Okay? Quickly, just some other thoughts about that. So, I think that this is something that's hopefully going to now change in light of the fact that we're having these big changes in law, is that I'm hoping that intellectual property laws that come out, whether it's the, something stemming from the bill, will be usable by every single person themselves without a lawyer. Okay? Please remember, you don't need lawyers for your rights or to draft contracts. Lawyers are amazing at self-insistence. Oh, no, you need us. You have to have us. You have to have us. I'm going to charge you 6,000 rand an hour. You have to have us. No, you don't. You don't need us at all. In actual fact, we confuse things on purpose because it just extends billables, it pads, and you know your business better than anyone else. And you know what you want better than anyone else. So what I'm hoping to come out of this current situation is maybe the laws we have going forward with IP will be as user-friendly as the Consumer Protection Act. I don't know if you guys have seen the CPA. You can read it. It makes sense. Let's do the same thing that has to be read by so many people because ideas are now becoming a huge, huge asset. One last thing just about that. And this is now kind of summing up about that, is that the enforcement, as much as we speak about the law, there will be the theft, and it's the enforcement of the law, which is always problematic in this country. Great, you got some great, you've got all these laws, great. Try go to the High Court and get a civil claim done in South Africa out of Gauteng. You're looking at 6 months, R250,000 just to start. Okay? So the legal framework, even with these formal situations, is not going to really help us. So going forward, and this is something I really want to inculcate with you guys, especially in the creative industries, take the power back. Understand the basic law yourself and understand the practical solutions that you have before you go to the attorney. The attorney is the guy at the end that just signs off. Don't use him for anything else. Because if you don't know the stuff well enough yourself, you're going to get fleeced by everybody, including the guy you're pitching to, everything. So please, guys, practical solutions, I think, in this field going forward. Take that power yourself. Know the law. Don't rely on the lawyer. Rely on yourself, and you can lean on them at the end. Okay, but theft is inevitable. Be ready for it, and have practical solutions for it, and make yourself the most valuable thing, because that's what it is.
Okay, that made me think a lot about, am I selling myself as a value proposition? So Elroy, the work that you do at Dalpro is very interesting in a sense that you're focusing on copyright licenses. How do I, as a creative entrepreneur in Limpopo, for instance, in Makopane, I'm running this great artistry film production with these young kids within the community, and this is a community work, and we're taping this, and we're filming it, and we're pushing it out there on social media because we want traction, and we want funding, And we want, do you know what I mean? We want exposure. We want people to know what it is that we're doing. But this is great content, because if I'm pushing it out there on Facebook, it'll end up on someone's page in Germany, and someone who has the money to actually push this on a much bigger scale. How do I protect myself when I can barely afford the resources of a cut Q roll?
Well, I mean, Thomas has it very right. I mean, when we talk, and I was literally in Polokwane last week, trying to advise authors and visual artists at University of Limpopo. We try and rely a lot on contract law when you're talking specifically about image releases and that sort of thing, particularly with the people that are party to that content, and making sure that your employment and job profiles are very clearly articulated through contract agreements. This is the difficulty when you're dealing with IP legislation across borders, because it is a minefield. Some of the stuff is reciprocal. You can only trademark and patent within territories. So if you want it to be protected, Apple is protected in every single territory, I mean, other than China, I suppose. Well, that's a given. And so you actively need to be looking at the balance. So what am I going to be making out of this globally, and is it worth the investment to legally protect myself in a variety of territories? And that's currently the best we can do at this stage. Everybody is posting things on social media, and I talked about visual artists doing exactly what Thomas was talking about, because it ties into what the woman spoke about with the social media presentation earlier. You are abiding to that platform's terms and conditions. You need to be conscious of what you are doing with your content and what contracts you are abiding by. But the moment you upload a picture, is it still your content? Are you in control of how it is reproduced, how it's adapted, how it's licensed, who uses it, who generates a commodifiable sort of revenue stream from it afterwards? You aren't. And obviously a lot of the things that we're doing is best sort of deterrence. That's all we can do. I mean, we can only put a little disclaimer on the bottom in our caption saying, not for reproductive purposes, please contact me if you'd like to license this work, or a little copyright thing. And then you get these people that still crop the copyright out of the image. So ultimately what you're doing is you're trying to prepare for the worst case scenario, hoping it will never come. We talk about old archaic methods of, once your manuscript is done, putting it in an envelope and posting it to yourself. Why are we still doing that? Because it's an old school copyright like registration, because we don't have a registration portal in this country. Blockchain will change that. I mean, America has a wonderful copyright bureau, but even that has limitations. And America is not really a really good indicator for IP all the time. Artist resale rights are a really good example of that. But this is the thing, when you're talking about, you need to understand, what am I doing with that film, that piece of artistic work, and where am I putting it? And who has access to that? So if I'm putting it onto a protected Wits University intranet like Sakai or something, then obviously there's a limited number of people that have access to it through a particular username and password, because they are students. It is not the World Wide Web. The moment you upload something onto the broader internet, anyone has access. So you need to understand with your content, okay, fair enough, I'd like to put a little bit of this online. What exactly is the limit for that exposure? I often talk about, look, if you're wanting to use it for marketing purposes, don't use more than 3 minutes of three consecutive minutes of the work. You want to use particular sort of excerpts that do not make sense together, so that you can't lose that IP, so that there's actually a reasonable reason, sorry for that tautology, for you to come to the theater work, or for you to buy a ticket to the cinema, so that you still have that access to that value that you're actually going to generate from. So yeah, it's complicated, it's a minefield, But I mean, from my perspective at Daura, because I mean, I don't charge 6,000 Rand an hour. I wish I did. But I'm just joking, Thomas. But honestly, there are places where you can literally give people a call and find out, am I doing the right thing? Like Daura is one of those places that you can do that.
It is not the World Wide Web.
We luckily
The moment you
all have
upload
to study
something onto the
copyright law,
broader internet,
so we have a fairly good understanding of the industry as well. We all come from, a number of us come from the industry, so we know the scope, and we know the country, and we know how the law is, how to navigate the law in our current situation. And we offer advice for free. So you give us a call, you say, look, how do you do this? And I will explain it exactly to you. And I'm not looking for a payment, it's fine. I get paid
Well,
from
now
Daura.
that you're offering your services for free, I would then open the floor to the audience to exploit you for free while you're seated here.
I'm not the expert. There's a policy and a lawyer here.
So I'm pretty sure our audience has had questions or issues or challenges they've faced around their IP or any creative trademark or copyright challenges you've had. Yay! Someone didn't get the cake.
Not really much of a challenge, but I just thought of the disclaimer you mentioned with regards to, like as an artist, if I want to protect my images. Even if I use, I have a website on a platform called Cargo Collective, which is like a build your own website platform. Would I just have to go through their T's and C's and to see if they, because then isn't my little disclaimer like rendered useless, because at the end of the day they actually own it, and if I just put this thing up it doesn't actually matter because I've already signed to them owning my content.
Here for free, so.
You're always going to be subject, there we go. You're always going to be subject to the terms of the platform which you put things on. So, as much as it is very important to make sure that you've got your own terms, unfortunately, because you're not in charge of the platform, you're not in charge of the general terms of use, as they call them. So unfortunately, they will stipulate them. However, some platforms allow you different permutations of ownership rights. I know the difference between Instagram, YouTube, Snapchat, they've all got very different permutations, and you need to be very clear about it. Keeping in mind that, yes, you can put the disclaimer on. What I would say is, make sure that what you're saying is congruent with what they're saying. Otherwise, they can just kick you off. You know what I mean? You wake up on Monday, they've just kicked you off their platform. But also, I wouldn't have any problem with you putting on additional conditions if you want. So if they're congruent and the platform says A, B, and C, but you want a higher standard of D, E, and F, put it in. And you can say that. You can have a little disclaimer, you can have little terms, and then the technical tools also work well. Yeah, what I was going to also mention is that when it comes to these ideas and putting things on platforms, don't put your diamond goods on the platform. The real good stuff, okay? Exactly like was mentioned. Give a taster, give a teaser, but not the one photo that makes you know what I mean, that's worth everything. Don't put that on, okay? But enough to get the people excited, okay? If you have your own platform, go mad. You can say whatever you want. Because like they said, you don't like those T's and C's, get off my platform.
Yes, I remember many years ago, and I think it's relevant, we were part of the Creative Commons movement, and I still think it's relevant. At the time, a lot of the issues you faced, some components of it could be covered in a Creative Commons. That means you as an artist allows the public to use some part of your music or content, and they, it could be non-attributable, and that created some sort of Ubuntu kind of culture. Sadly, I think that has died down. Everybody's in monetizing. It's also the market structure. We're all in the gig economy, so a typical artist would be doing 3 or 4 different kinds of work in 3 different subsectors, and he or she needs to better understand those dynamics in each sector. So, I could throw it out there. Should we relook at Creative Commons? Is it still relevant? Maybe for some artists it is that are starting out. There are different, as the colleague said, different layers in how you can protect your content. Also, we must realize we have a very good constitution. It's a very progressive constitution. We have a Bill of Rights. And I'm not sure how many artists realize that they are protected in the Bill of Rights. You know, we don't normally use those kind of first level generation rights. And then also the constitution. I believe in the last judgments, Judge Cameron has made a huge socio-economic perspectives on all rule of law. So, you know, we in South Africa, we have that strength that we have a strong constitution that's looking at the development perspectives. And that's one strength. But we also need to learn from other countries. Obviously, if you're in India, it's really challenging. There's high levels of piracy, for instance. I think 70% of everything is pirated in a country like India, China, etc. So we sort of somewhere in the middle. So South Africa is not too in a bad space, but we're also not in a good space. And I don't know where we want to go in terms of these legislations, but I think there could be some sort of better debate on these 3 or 4 legislations that impact on the creative sector. Should there be silos, or should certain things be in certain legislations? I believe it was a very strong lobbying process by industry to get certain things in different legislations. And that's the norm of Westminster type of constitutional democracies where corporate power can buy the best lawyers, apologies. But I'm talking of the big law firms out there in Sandton. There's a joke the other day, they said, you know, if you drive in Sandton, you'll see that the top 5 law firms, their headquarters is even more fancy than the multinational corporations. Yeah, go to them, Weber and all these things, which shows how lucrative corporate law is in South Africa. And it's not like that in many parts of the world. So do you want to have a legal litigation kind of model? My own main concern with the copyright bill is that, you know, reading the different critiques, and I don't have any strong views, is that we may get into a litigation kind of system, like a US model. And I think that's very expensive for artists. Because you're a single artist, you're going to have litigation with a record label or with a large or external company, you're going to lose. So, you know, we need to have that debate as well.
Just sharing a mic. Oh, there's a question at the back. Can we get the mic to Yamisi?
Hi. My issue is that this topic comes up decade after decade, and I don't think people are really addressing it. So the whole point of the creative industries is it's the knowledge and information sector. And so the way you make your money is from the intellectual property. So when you're trying to get investment, that is what they're putting their money into. So I'm kind of like a little bit sort of thinking to myself, no, we should be getting into that kind of like aggressive framework, because when I look at, say, things like musical theatre, the reason why there's so much respect for a score of music is because everyone understands that if you try and do Oliver the musical, even at your school, you will lose, you'll go to court. And I really feel that we have to have, I just want to know, where do we sort of like start to have more structured, and I'm going to use the word aggressive, IP laws that we can actually influence and we can really put in, because we're not making money in the creative industries because we run off our intellectual property. So it's nice, I agree with you, yes, you have to sell yourself, but no investor wants to invest in you because you might not be around tomorrow. So, you know, how do we become stop having this kind of continual soft approach, but actually demand our intellectual property rights and demand that governments and legal practitioners actually, you know, aggressively look after them?
Absolutely. Listen, I think that as far as tech goes, I might disagree on some point about the value of the person versus the object, in the sense that, you know, in the last 3 weeks alone, I had the exact same marketplace pitched to me by 7 people in 7 parts of the country. And they all did it brand new. Okay, then no one talked to each other. I think that there's a proliferation of so much stuff that in actual fact, we need to position ourselves to understand that it's, my own opinion, what I've seen is the ones that have succeeded, the creatives, the people that had intellectual property assets that have gone out and monetized it, were because of the people, not the product. That's what I've personally found, just from things, because yes, you can create a different marketplace. Yes, you can try things a little bit differently. You can create an artwork a little bit differently. But you need to set yourself apart by the person you are as opposed to just the object you make. Again, that's just my kind of thinking. Talking on your point as to I absolutely agree with you on the sense that whatever legislation goes forward, it must be absolutely realistic about the situation. That is undeniable, and you're absolutely right on that. And I think that currently with the bill, it's unfortunately the exact opposite. They try to have an original idea of trying to disseminate as much information as possible to promote and stimulate creativity by pulling the rug out of every creative author's feet. Saying essentially, yes, you've got stimulus to create, but we're not going to pay you for now what you create going onwards. That's shocking. I don't understand that. It makes zero sense to me. And unfortunately, what we did is we also took an American model and then we didn't make it particular to South Africa, which again is another situation. You know, I was speaking about this at the Cannabis Forum, the South African Medical Research Council. They're calling it Canadalization. They're not calling it legalization or medical thing of the marijuana industry. They're calling it Canadalization, meaning we're taking a foreign system of law and applying it here. And it makes no sense. And this is one of the biggest dangers of the bill, is that it's doing exactly that. It hasn't been incorporated into SA and thinking about those things. So I think you're absolutely right in that even if we disagree on exactly the aspect of the element, that must probably be one of the biggest focuses that is obviously apparent in SA. And we've got various opinions and ideas, but that must be acknowledged. And the problem is the bill got, what, 10 days discussion, public consultation? 10 days. And that is just shocking.
Just on that point as well, I mean, what we're finding is that these sorts of consultations need creative voices. And we're not getting enough of that in the discussions, I mean, specifically in South Africa. You have these massive bodies that are representing their constituencies, i.e. the publishers, the rights management organizations, and all of and these sorts of organizational bodies that are making sort of they're making these submissions to Parliament. But the voices of the artists, that critical mass of people who are actually affected and whose revenue streams and pockets are, at the end of the day, directly affected by this legislation, are not coming to those discussions. So the impressions from the legislators are that it's these corporations that are making the money off of the backs of the artists and the authors that are the only ones that are speaking up in these forums. And there's not enough critical mass from the industry itself that is causing a lot of subterfuge around information, unfortunately. So if you are able to group together a wonderful contingent of authors and artists and creators together and march together, do that. Because nobody wants to see a whole lot of rights management agents run for you. No one's going to pay attention to that. So they actually want to see the people that are directly affected by this legislation making their voices heard. And unfortunately, not enough of that is happening.
Ashraf, I'm going to ask you, because you did touch on lobbying and the spirit of Ubuntu. And from a policy context of the forever, I feel where we are as far as digital spaces and IP, it's forever changing. How do you put together, or how do we expect government or the policy makers put together a policy framework that is not open-ended, that's open to change and innovation, right? Because yes, tomorrow we're looking at blockchain, and tomorrow and the day after that, it could be a different technology that will need more protection from ourselves, from each other, and from the government. How does government, civil society lobby not against each other, but for each other? How does that work in a policy framework?
Sure. And, you know, I concur with a lot of the points of my panelists. And to answer your question, it's a very good question. I think the best way is put ourselves in the shoe of the ordinary creator. particularly in Africa. I think African content is got so much potential to go global. It is, I think in Europe, it's highly regarded, but in other parts of the world and within African markets, we don't fully appreciate the diversity of content. And with the information economy, smartphones, and all the free platforms, if you're an up-and-coming artist, it's your best hope for a better life. So it's definitely a livelihoods issue. So legislators and researchers and institutes, cultural institutes should look at enabling that. We should not get too caught up in the legalese, but you're right, at the end of the day, a small contract or clause can mean difference between that artist being sustainable for many years or just being in many ways marginalized. And that is, for me, the gap. How do we educate the artists or the creators on their rights? And obviously, you don't want them to be involved in legal fights. I mean, they need to do the creative stuff. So it's a chicken and egg. And with a good team, I agree with fellow panelists, it needs more research. We need to look at other components of the legislation, other parts of the world, and how they are dealing with a very complex emerging knowledge economy and capacity of enforcement. Legal systems are different in different parts of Africa. I think here we've got fairly developed, whereas if you in another country, it's less developed. So how do we work together to educate the artists? But any system that just exponentially increases the ecosystem, the cultural ecosystem, is important. I mean, we did a study on the Africa Free Trade Agreement, CFTA. Now that's looking at free trade of goods, a little bit about services, and we need to start looking at where the cultural industries fit in that. Because as we reduce barriers, the free flow of culture is one of the key drivers of economic growth. I think the EU is the best model. Every EU country, the cultural sector is in fact the most protected. I mean, you get into any EU country, Germany, France especially, their artists and authors and musicians are treated like royalty. I mean, really, I mean, you'll never get an artist in Germany or France living in poverty. I mean, they are highly regarded. And they have cultural funds. I mean, any author or prospective author or artist in those nation states can literally access a fund, a cultural fund for any publication. And that can keep he or she going. We don't have that in South Africa. So there's a lot we can learn from those kind of economies and jurisdictions. So I think it's a great debate, but we need to put the common person on the, take his or her view, and the law must protect. In my understanding, constitutional democracy is the law should protect the weakest at the end of the day.
That's very interesting. I'm going to come back to the law protecting the weakest. I'm going to open the floor again to the audience. I'm not sure if you guys have any inputs or suggestions or any pain points that you'd like to put forward. There we go.
Hi, I have a question about domain hosting. So if I have my platform and the domain is hosted by Google, does Google own my things, or are they my things?
Quick answer to that, check the T's and C's when you sign up. Every relationship that you have, every service you get, it's got a fat batch of T's and C's reduced to one click. Right? That single click when you push register, confirm, submit, buy, purchase. There's a 45-page document attached to it. It will definitely discuss intellectual property, and it should break it down as to what, when, which little bits, when you can, when you can't. Unfortunately, it might be hidden in legalese, all the jargon, they try to confuse you. But remember, because it is such a valuable asset to you, you need to take a bit of impetus and push a little back. So there's no reason why you cannot contact these service providers and ask them, can you please explain certain of these permutations? They absolutely can do it, and they're quite responsive. Okay? But everything is going to be housed in the T's and C's, whether it's an ISP in South Africa, a provider overseas, everything. Just one quick thing about provision overseas, guys. Any contract that you sign will be subject to a system of law chosen by the provider, not you, nor where you are. So what will probably happen is in that Google contract, what does it say? All disputes to be handled out of Ireland. Excellent. I have to fly to Ireland now to go deal with this. So it's shocking. Please make sure there's T's and C's. And I know we kind of held ransom in a sense. And listen, do you want to use WhatsApp or you don't want to use WhatsApp? You need to accept the T's and C's. But what's also great is in the face of that, we are getting a bit of pushback and people are starting to offer services where they don't have such severe T's and C's and they derive an income other ways. So those also, look out for those optional other service providers as well. They're getting there slowly, but Google is still obviously your biggest. But other people are coming in that won't force you to be subject to very onerous T's and C's. Okay, down to the T's and C's.
Thanks.
Just to add, I fully concur. And definitely look at, you were correct, the consumer rights legislation or consumer protection in any country. As ours is quite progressive, as I understand it. Also, there's a mushrooming of a lot of incubation hubs across the country. I think 5 years ago, we just had a few big names. Today, there's over hundreds of incubators all over, and thousands of entrepreneurs converge in these spaces. I'm not sure if entrepreneurs are aware, what kind of contracts they sign, with IP, with hubs. That's also important. I mean, sometimes, there are some hubs that are public, some are private, some are semi-public. What is the, let's say, the organizational form of those hubs? What are the elements of your non-disclosures? Those kind of issues one should also look at. Do you want to use a law? What kind of law you want to apply? It's very important because in the network economy, your knowledge is distributed on so many different platforms or devices. It could be at the server here or at another hub, and you may lose it to a third person. What happens then? Who do you actually claim or enforce your rights? These are kind of things that artists in particular don't look at, or entrepreneurs don't consider. So you need to have your IP strategy quite clear. It's important, yes.
I think just before we wrap up and I allow each of our panelists to wrap up, Ashraf raised something that's sort of an itch in my head around about protecting the minority, right? And everyone, and Elroy spoke about everyone has a right to be more expressive, right? The Constitution, the Bill of Rights, and the creative society and artists and film having the opportunity to be more expressive. What we're seeing, particularly here in the continent, is that as creatives, we'll make a movie that's very taboo to traditional government, but it's a discussion and a conversation that has to happen, right? Either around HIV and AIDS or around homosexuality. And I published this, and there's an entire film industry that's meant to be behind me and protect me as an artist. And what happens is my film then gets banned in the country. Now, the audience that I made the film for does not get to enjoy the film. Where does the legal framework come in this instance? Are we having these conversations as legal and policy makers around how do we protect minorities and how do we protect expressive and liberal content that's more educative? And yes, Thomas, you might not see it as educative. You might see it as offensive because you believe in a certain worldview. But I'm an artist, and this is how I'm expressing myself. How am I protected in that sense? Are we there? Are we getting there? Are we moving there? Or are we just at the mercy of government not banning our copyright or our films?
Just
From my perspective, I do know that there are there's at least one postgrad student doing a research paper specifically on Gleba, and the censoring that took place there. But I mean, we've got exceptional freedom of expression legislation in our constitution, and it would also when you are put in a position like that, it is up to you to just figure out, okay, which angle am I going to fight this at from? I mean, cannabis is a perfect example where it failed when it was a religious perspective, but it passed in terms of privacy. So it's about understanding which angle you're going to use the law to your benefit. As Thomas said, it's a tool. The law is a tool that you're going to use, and you're just going to find the best spanner in that toolbox that works for you. Ultimately, we do have a very a society that, well, not necessarily a society, but a legislative framework that lends itself to a very liberal environment. Our society, in many ways, still needs to catch up to that, and we have ongoing court cases where we're testing what the limits of that are in light of our society's efforts to catch up to where our legislation is. But yeah, I think it's very interesting. We're living in a very interesting perspective where, I mean, money talks. So the Indigenous Knowledge Systems Act, for example, specifically excludes medicinal knowledge, where indigenous knowledge groups cannot benefit from medical knowledge or medical plant knowledge that they know of, and that's obviously lobbying from the pharmaceuticals. And we've also got disconnects between policymakers and legislators. So you've got a wonderful white paper that has just been drafted, the 2017 white paper that was written for the arts and culture industry that speaks about intellectual property in certain parts and has a wonderful aspects about how the arts industry should be growing over the next 5 to 10 years. But then we have legislators who haven't read it. And particular siloed industries and departments that don't read across the corridors. So you've got this wonderful white paper from 2017 now that hasn't essentially been ratified or come into force, but it's been circulated to all the different departments, but the legislators are from the Department of Trade and Industry. So no one's reading across the corridors, and that's also frustrating for people that have all of this in front of them, like us who are in the industry. We see the different forms, we see the different paperworks, and we see, but you haven't actually read this from your neighboring department. So I suppose those are all stumbling blocks that we need to overcome. But I don't know, perhaps Thomas has a different perspective from a legal framework.
Wrapping up, Ashraf, I'm not sure. Before we get to Thomas said, ooh, so I'm assuming he's applying his mind to it.
Yes. No, it's a fascinating debate. I mean, to answer your question, in the 80s you had graffiti artists. And so arts as protest is a phenomenal space, especially, in authoritarian situations. And so in, let's say, in the old East Europe, and now you have even in South Africa, if you remember the 80s and early 90s, that was an important area of expression. In the digital age, there's no doubt that if you want to self-publish any content that may ruffle the feathers of the authorities, you just put it on a server in another country. And there's lots of tools and technology that one can do that. And that has the unintended positive consequence that anything controversial will attract attention. So you'll have the beehive effect. And so it's a good thing. So whatever you want to publish, there are the tools and technologies out there, and it can and should be used. It's always the issue of the platforms. So the YouTube model is a monetized model. How do you, I'm not an expert in these areas, but I would imagine you get money based on how much views you have and those kind of things, which we need to visit as well from an African perspective. I know in the EU, I'm in favor of the EU model, as I've mentioned, is they always put their local cultural community first. And that is why you see the EU is at the forefront. Any large corporation, whether it's Apple or Google, that infringes on their jurisdiction, they get huge fines. And we don't have the power here. So there's a lot we can learn from that experience.
We have a long way to go. Thomas, your wrap-up comment?
Just my little wrap-up. I thought I might as well throw some practical bits in here. We've been very philosophical. If there's anyone that has, obviously, I'm sure all of you have your valuable IP, there are some recurrent things that we see non-stop, okay, with all of our guys from small to big and everything. Number one, the default position in law is that if someone pays you to do something, they own it, all of it. But you can contract out of that position. Please do not get forced into thinking, this guy commissioned me to paint an artwork, all of that is just naturally his. No, 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 no. By default, it's theirs. You can contract out of it. Where do you do that? In your service agreement with your client. In clauses, what is yours, what is mine, what do we do with derivatives, what do we do with raw footage, B-roll, everything. Put it in there and go crazy, ad nauseum. The more detail, the better, less room for disputes. Okay, so the default position is they own it, you can change it. Number two, very important, a lot of people don't know this. If you move IP outside of the borders of South Africa, intellectual property is considered capital under exchange control regulations, guys, like finance, cash, securities. If you send a picture that you took to a gentleman overseas who paid you for it, you have to get SARB's approval, the South African Reserve Bank's approval via a bank. You actually have to go to a bank, and you have to explain to a bank manager who you're sending that picture to, and you need to provide an invoice showing that the money has come back into SA. Why is South Africa scared of this export of IPs? It's worth so much, and government is worried it's leaving our shores. So they have created some sort of exceptions, R&D, TMT, all these things. But guys, if you send your IP overseas, and you get a nice fat check for it, when that fat check hits your bank account at FNB, you're going to get a phone call from SARS. And they want to know where that money came from. And you need people to explain it. So please be aware about cross-border movement. And the last thing is censorship. They would hate me to say that they censor. They don't censor. What do they say is they say, we inform, you choose. It's the FPB, the Film Publication Board, guys. If you've ever sat down with them in their current legislative process, you will understand that they've got a very different agenda to what is currently going on with the rest of other people in South Africa, and the creatives especially. So please, and this was about the censorship aspect, you may be subject to them. Please be aware that they are thinking slightly different from what you are, and you may have to just deal with them. Okay, their laws are currently changing, the laws are shocking, but it's hopefully in this flux where things will get better. But if there's censorship issues, if someone's telling you no, it's probably the FPB. Okay. That's me.
I think if I've learned anything this afternoon is protect yourself, stay private, and protect yourself. Can we please give our panelists a round of applause? Thank you so much, gentlemen. Thank you for being great sports. You can go ahead and take your seats. Well, this is me wrapping up for the day. It's been a long and fruitful day. I hope you guys have enjoyed it as much as I have. From Ashraf's presentation this morning around business and art and collaboration, and his slides and his presentation around where private sector is funding creative arts, to Obasi's Skype call, where he spoke about, how he got into the film industry. I thought that was really impressive and very informative. Just a reminder, his screening is this Friday for his movie, so please go and watch. And Russell's presentation was very informative and very insightful around the dark cloud. I thoroughly enjoyed the panel discussion on the ecosystems on technology, as well as the Our Space presentation and performance outside just after lunch. I thought that was great. I'm still a bit sore that I was not part of that WhatsApp group, but it doesn't matter now. And the great lunch, I think it deserves the credit. And just the last panel and the presentations on social media. And I think Sarah's presentation stood out for me in a sense that it's the little things that we do not take note of when we're engaging in social media. And I don't think she was here to scare us off. I think she was just saying we need to be vigilant now that we're existing in the digital age. And in the same way how things are constantly changing, we need to protect our space and protect ours, particularly, and protect the people that we work with and work for, and that we are moving digital footprints. So just because you can't find yourself when you Google your name on Google, you're not rocking up in a Wikipedia profile. Your profile is there, and that is what I've learned. And our current panel discussion that we just had right now, I think that was very informative around frameworks and legal spaces. I'm basically moving away from today, already geared up for tomorrow. I want to know what happens tomorrow, what panel discussions are happening tomorrow. But just before I close off, I'd like to make a list and just a few credits. We'd like to thank Project Management, Bandile Gumbi, and with Sandile Makatini and Lots. Thank you so much. What a great day of the first of the conference. Thank you so much, Fiona and Dr. Tegan. And for the Creative Economies projects, and to the Goethe Institute, Dr. Klaus Krishok, Naomi, Dr. Nadine, Julia Schleller, and Jonas Randuns. And I'd like to thank the security outside, the catering. The food was amazing, the coffee woke us up, and the cake was amazing right now. And thank you guys for being such great sports. And I'd like to thank you for giving me this opportunity to be your MC. And look at us, we're still awake. But just before we pack and we go up, there's a networking session upstairs at the courtyard. And there's a cash bar available. For a second, I almost read open bar, I kid. It's a cash bar. And just a reminder, the We Are VR session 6, they usually have their sessions around this time, so you can go and join that while you mingle and have your drinks at the cash bar. And please come back for day 2 tomorrow. It's going to be more exciting and more fun and more informative. Thank you so much. Have a great evening.